on others. So it was a parliamentary act which required the court to make it compatible and tell the House. It is actually, this is an advisory jurisdiction, because as the Lordship saw in section 3, which I have quoted at page 12 and 13, at least at page 13, subsection 6.
Yes.
A declaration under this section does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. So this is a very peculiar, it's not a provision of judicial review at all. It's more like an advisory jurisdiction.
What's the next point, Mr. Dwivedi?
Which separation of powers then in fact, after the court has given the judgment in Khaidan, the Parliament is quite competent to take another view by passing an amendment.
All right.
Now, so far as separation of powers is all well settled, my lords, and I will only request the Lordships to note the judgment at page 19. This is, my Lord, the Chief Justice's judgment, my Lord. I'm sorry, my Lord, the word J is missing there.
Page 19.
Satpal Saini.
Yes.
Para 12 particularly, the Lordships have said that each branch is equal, and there should be no encroachment. The courts do not frame policy or mandate that particular policy should be followed. Duty to formulate policies entrusted to the executive. The accountability is to the legislature and through it to the people. The peril of adopting an incorrect policy lies in the democratic accountability of the people. That's para 12, at page 20. One interesting feature, my lord, to be noted is about separation of powers. If your lordship looks at it for a second, it talks of, that's the Constitution of India, the Article 50.
Separation of the executive judicial. What do you want us to look at, Mr.
Article 50 in the Constitution of India, separation of powers. Hello, Justice Call has, Manoj?
Yes, please.
50, separation of judiciary. Oh, yes.
The state shall take steps to separate the judiciary from the executive in the public services of the state. It doesn't talk about parliament, Lord. Now, there is significance, Lord, because I have quoted a number of articles where, Lord, Parliament has in the judicial domain power to make laws, Lord. At page 21, your Lordship will find in bold.
Actually, Article 50 was enacted in a different context, because actually even after the Constitution, until recently, there was no strict separation between the executive and the judicial functions, especially in the district judiciary. The idea was to ensure that the district magistrates, for instance, don't exercise the powers of a civil court. Even today, until recently, in the Northeast, for instance, even today.
Commissioners and all that.
If you could have
I have not drawn the Lordship's attention to say that this is something decisive about the range of the manner. But because separation of powers is to be deciphered by referring to all provisions of the
exposition is in Indira Gandhi.
Yes.
Indira Gandhi.
Yes.
What is separation of powers in India?
So, and directly of the Constitution has
Mr. Dwivedi, this is very well settled. Yes. We can move on to the next point.
Kindly, Lord, just note, Lord, three cases at page 24 and 25, where writ petitions demanding a common civil code, your Lordship said it is for legislation. Then Hindu Adoption and Maintenance Act, your Lordship says areas and aspects or facets of Hindu law which require modernization, modification, or are matters of legislative policy. That is 24 bottom, and then at page 25.
Of your note?
Yeah.
Page 24 bottom.
Cut.
And running to page 25. There are three judgments where in the field of reforms, social reforms, that It is for the legislature. The last one, my lord, is an order, my lords, in writ petition number 319, which wanted the court to intervene with regard to dowry menace, and so on. The lordship said legislature. All right. Then next page, I'm not reading, my lordship. Some foreign judgments are mentioned in the same direction.
Same-sex marriage. 29 members.
If your lordship comes to page 29, this is in the same sex context. My lords. This Auberge fell, my lord, of course, is there, but we have quoted there also at page 26, 27. Just take the same view, and if your lordship recollect, they only issued a declaration leaving it to the. Then page 29 is shoot as coalition.
Right.
Where the same, my lords. And 32 is Israel, where a foreign marriage, my lord, was the issue to be, it was not being registered in Israel. Para 33 is Panama, my lords, and it also mentions Thailand. These judgments are there in my compilation, lords. I'm not reading, it's all in the same direction. Interestingly, Panama is very close to America, my lord, yet discordant note. Now, kindly come, lord, then I come to Article 14. Because the first question is there a fundamental right, my lords, for persons in same-sex relations to marry, my lords, either flowing from Article 14, 15, or 21?
What is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself
Right
is not
to
qualified.
life is not
Can be
unqualified.
taken away on
Therefore,
conviction.
we don't start with there is no unqualified right. There is no absolute right. If we start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? Do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion, and that has been continuing. That's the foundation of their right. Now that right has been.
So, but therefore you concede the fact that therefore there is a right to marry under the Constitution.
Sure.
But that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right?
I'm saying there is a right to marry which is founded on customs, personal law, and religion. The
In
enactments
that case,
passed-
as you taking the same argument further,
yes,
custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right?
So there-
Interfaith marriages were unheard of,
yes.
right? So all this, the content of marriage has changed. Therefore, what was the fundamental right to marriage in
So
1954?
these
Or
changes,
core content.
these changes therefore have been brought about by legislation, and legislature can certainly alter the customs, and now the ghost of Daratu has been.
Keeping aside for a moment the legislative aspect, as you said, it's the culture, it's
Yes.
the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
So the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, Muller, and two people coming together and say, call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the Constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the Constitution came in, is it your argument that the marriage was...
So that right to marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. Asking to open the doors of this social institution of marriage as existing for them. And that's the plea, that we stand at par for various reasons and therefore make the amendments in the SMA. SMA has now become unconstitutional, violative of Article 14. It may not have been violative of Article 14 in 1954-56 when a cluster of laws were codified.
By the same token, the Constitution has not granted anything. Go by the theory of the dissent in the habeas corpus, or even by what is generally accepted. It only recognizes and guarantees. Nothing is granted. We are free citizens. We have taken this onto ourselves. So the right to speak, the right to associate, everything is part of our inherent rights.
That's right.
Constitution,
Yes.
therefore, does not grant. So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see was in terms of association, as we understand.
So it doesn't matter where it is located or taking together, it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which...
This is the problem. The moment we qualified with in the sense, because
That's important.
when you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so,
So
let me
I
just come.
appreciate.
If you brought in 14, if you brought in 15, and most importantly 17, those traditions are broken.
It can be
That-
broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste? We made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say an outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. Created the tradition, the institution of marriage, but at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, my lords. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also, my lord, adverted. The point is, all these reforms which have happened are reforms, my lord, which are made by the legislatures in the interest of women and children. And they do not alter, my lord, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather not Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or not the fact that some other modifications have.
But, yes, you're right. That is
So-
by and large. But
So, but
Even Hindu-
each and every reform, not kindly see 1937.
we are looking at that. We understand as the traditional, but there are large parts of society. It's a very diverse Hindu society. That diverse society, even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes,
The diversity is there. That diversity we can.
correct. So, therefore, what I submit is that the core aspect, what is the core aspect of that marriage?
That is
You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be intercaste marriages, but ultimately the marriages remain heterosexual marriages. And number two,
Mr. Dwivedi, there are certain, to state at the extreme that there is no fundamental right to marry under the Constitution would be far-fetched. What are the core incidents of marriage? If you look at the core incidents of marriage or the core elements of marriage, not the incidents, I made a mistake. What are the core, what is the core content of marriage? Or what are the constituent elements of marriage?
Lord-
Just one second. If you look at each of these constituent elements, each of them is protected by constitutional values. I'm not saying 21 necessarily, but constitutional values. The
Yeah.
preambular values read with 14 and 21. One, marriage itself postulates right to cohabit, right? Of two individuals to cohabit together. Two, marriage accompanies with it the notion of a family, the existence of a family unit, because the two people who come together in a marriage constitute family. Again, something which directly owes its existence or recognition to the constitutional values. Three, to bolster your submission, we must take that into account also. Marriage has procreation as a very important ingredient of marriage. Though equally we must be cognizant of the fact that the validity or the legality or the social acceptability of marriage is not conditional only on procreation, for the reason that people may not want to have children. People may not be in a position, have the ability to have children, or they may get married at an age when they cannot have children. But we therefore take your point that procreation is a significant facet of marriage. There's no denying the fact, subject to these caveats. Four, marriage in a significant way is exclusionary of all others. Two people who come together in a marriage or want to cohabit together are entitled to exclude everybody else from that area of marriage. No third member of society can say that, well, I want to share in the same relationship which you have with one of you in the marriage. It's exclusionary of others. And five, which is equally important, as I gave you that thing about procreation, which is social acceptance of the existence of marriage. And social acceptance is then not just confined to that individual, but to the how society itself looks at that institution. Now, having said that, there cannot be any denial of the fact that the state has a legitimate interest in regulating marriage. Undoubtedly. Therefore, the state that's how the state regulates the forms in which you can enter into marriage. The state regulates how many people you can enter into a marriage when you have a subsisting marriage. The laws against bigamy, for instance. The state has a variety of other interests so that it regulates various facets of marriage. But we must therefore accept as a basic proposition that marriage itself is something which is entitled to constitutional protection, and it is not just a matter of statutory recognition. Once we cross that threshold, then we enter into the next level, which is that which is the contested issue here, is heterosexuality an intrinsic or core constituent element of the institution of marriage? Your submission is that as marriage has evolved, and even today, whether it has heterosexuality has social acceptance or not is one thing which regulates the state's interest, because the state has a legitimate interest in regulating in marriage, and therefore it may say that I'll not recognize anything beyond a heterosexual relationship for the purposes of marriage. That's your contention.
No. So may I respond on this?
I just want to add something. Actually,
Yes.
the Chief Justice has, I had written something and the Chief Justice has virtually echoed the same thing, but I put it slightly differently.
Yes, ma'am.
I'll just read it out. What is the content? After all, what is a marriage to each other? One is to society. What a marriage to each other, each spouse, they decide what that marriage means to them. So what is the content of a marriage is defined voluntarily by the parties. That is the spouses. They decide, number one, whether to have and raise children, the procreation part. It is entirely their choice. Of course, there are social pressures. We are all aware of it. But ultimately, at the core of it, whether I will have child or both of us will have children or not is our autonomous decision. There may be marriages where parties may not live together. There is no cohabitation.